পিটিশনের জ্যোতিপ্রকাশ চ্যাটার্জি।
My lord, your lordship has been placed the SOP. My lord, the first heading of the SOP says rationalization of, my lord, page 17, rationalization of surplus teacher. My lord, any rationalization should not be irrational. It has to be rational. Now, my lord, I would say this whole concept of surplus teacher, deficit teacher is a, my lord, vague term, because, my lord, according to me, my lord, there cannot be any surplus teacher. Cannot be. Why, my lord? The concept of surplus teacher, my lord, as has been taken by the state authorities in terms of the, my lord, pupil teacher ratio. My lord, the pupil teacher ratio is stated in the schedule. My lord, your lordship knows any schedule to an act cannot, my lord, run independently. It is in aid of the particular act of or provisions. My lord, if your lordship kindly comes to the Right to Education Act,
It is here.
the schedule, my lord.
Yes.
My lord, the schedule below it is stated, see section 19 and 25. My lord, let us read section 19, my lord, for your lordship. Section 19, my lord. Norms and standards for school. Norms and standards for school. No school shall be established or recognized under section 18 unless it fulfills the norms and standards specified in this schedule. My lord, now subsection 2, where a school established before the commencement of this act does not fulfill the norms and standards specified in the schedule, it shall take steps to fulfill such norms and standards as its own expenses within a period of 3 years from the date of such commencement. So, my lord, what this, and my lord, it says section 25. Thereafter, I will come. My lord, now kindly see section 25. Pupil teacher ratio. Within 3 years from the date of commencement of the act, the appropriate government and the local authority shall ensure that the pupil teacher ratio as specified in the schedule is maintained in each school. Subsection 2. For the purpose of maintaining the pupil teacher ratio under subsection 1, no teacher posted in a school shall be made to serve in any other school or office or deployed. My lord, I stop here for a moment. Shall not be posted in any other school for the purpose of maintaining pupil teacher ratio.
No, no, no. Complete the sentence.
Yes. Or
For any non-educational purpose.
office or deployed
For any
for
non
the educational purposes, non-educational purposes. My lord, deployed, when a teacher can be deployed, that has been enumerated in section 27. Except in census work or election work, a teacher cannot be deployed in non-educational purpose. And a teacher cannot be posted in any office or, my lord, in any school, deployed in any non-educational purposes. That is together. Now, my lord, why I am saying this? An act is to be read in its entirety. Now, my lord, kindly come to section 27. What does it say? 26 rather. Filling up of vacancy of teachers. The appropriate authority in selection to us in relation to a school established, owned, controlled, or substantially financed by, my lord, so and so by the appropriate government or the local authority shall ensure that number of teacher in a school under its control shall not exceed 10% of the total sanctioned strength. My lord, this presupposes that my lord, what the schedule prescribes is the bare minimum. Otherwise, this filling up of vacancy would not have arrived commensurate to the sanctioned strength. My lord, your lordship knows, my lord, every post in a government institutions, my lord, must be sanctioned for an appointment to be made. So, my lord, if there are 10 sanctioned posts, a vacancy shall not exceed more than one. If there is vacancy, it has to be filled up. Now, my lord, what the authorities are working on, that the pupil teacher ratio for 60 students, the teacher's requirement is 2, and that is more than 2, it's a surplus. It cannot be, my lord. Because, my lord, if that be the so, then 2 has to be read as maximum. If 2 is read as maximum, then, my lord, the whole scope of Right to Education Act will be defeated, because if a figure is maximum, I can be less than that. But if a figure is minimum, I cannot be less than that. Suppose, my lord, if 3 teachers for 60 students, the third teacher is considered to be the surplus teacher, then, my lord, it has to be considered that 2 teachers are the maximum permissible limit or the maximum sanction strength that can be appointed. So, my lord, that authority then has the liberty or has the, my lord, power to appoint 1 teacher for 60 students. Then, my lord, the very scope of Right to Education Act will be defeated. So, my lord, now lordship kindly comes to the schedule. Schedule says under section 19 and 25.
Probably the surplus, what you are defining surplus is showing that this is not the maximum limit. This is the minimum limit. You say minimum limit. In that context, for rationalization, to have minimum teachers in all these schools, they define it as surplus. That doesn't mean surplus means you cannot scale over 2. Minimum is 2.
So grateful to you all. That is the point I was harping on. My lord, that means, my lord, a school may have 3 teachers for 60 students. That doesn't mean that the third teacher is a surplus. But, my lord, where suppose there are 60 students and there are 1 teacher, then the authority has to, from somewhere, has to meet up that second teacher.
Yes.
And now the question is, my lord, the mechanism and determination of surplus. Mechanism and determination. My lord, what the authorities has proceeded with, that only the schools having more than, I'm giving only 60 example for, my lord, in a school where there are 60 students and 2 teachers, the third teacher is a surplus and that school has been named in the surplus list. 1 teacher is surplus. Second, my lord, they have proceeded that in a school, suppose there are 340 students. In case where there are 200 and more students, my lord, the RT Act prescribes that there shall be an head teacher and the pupil teacher ratio shall not exceed 40. Kindly come to, my lord, the schedule. My lord, the last one, above 200 children.
Yes.
Pupil teacher ratio excluding head teacher shall not exceed 40. That doesn't mean, my lord, it has to be 40:1. It means shall not exceed 40. Now, how the authority has proceeded? Authority has proceeded for 340, 10 is the minimum requirement, 40:1, and the remaining 14 teachers, suppose there are 14 teachers and the remaining 4 teachers are surplus. This cannot be, my lord, because it shall not exceed 40. Below 40, nobody is surplus. My lord, what I am submitting, the mechanism of surplus determination is itself faulty. My lord, in the present writ petition, my lord, there are, this petitioner was appointed in 2014. Now there are presently 46 students and 3 teachers. Now, my lord, my school, this petitioner school, has been put in the list of surplus school. Why? Because they are following as if 60 is the bare minimum and there should be 2 teachers. Third teacher is there and he has been shown as surplus teacher. And why petitioner has, before your lordship, petitioner is younger in biological age. My lord, younger in biological age, I will come later. My lord, so my lord, the very mechanism of surplus determination is faulty. It cannot be. What has fallen from your lordship, my lord, I bow down, is absolutely correct. Third teacher is not the surplus, but where there is one teacher, this appropriate government will take steps so that to meet up that bare minimum of two teachers. Secondly, my lord, now what is the minimum requirement? RTX says for recognition, this is the pupil teacher ratio you have to maintain. Now, my lord, a primary school runs from pre-primary, class 1, class 2, class 3, class 4, class 5. So, my lord, a school to be run simultaneously, 6 teachers is a bare minimum in every school. Otherwise, my lord, suppose if there are 60 students and 60 students are distributed from pre-primary to, my lord, class 5, where the age group is, my lord, around 5 to 12, a class will be left completely vacant, my lord, completely vacant. And other teachers, we don't know what the students will do. Even they can go outside of the school, so and they will not be what the right to education prescribes, my lord, compulsory education. Compulsory education means, my lord, every student has to be taught. Now, my lord, if there are two teachers for 60 students distributed from pre-primary to, my lord, class 5, no students will get. I can demonstrate, my lord. If one class will be deprived of education every day, how? My lord, a primary school, a day primary school runs from 11 o'clock to 3:30. Half an hour, my lord, minimum half an hour is the recess time. So, my lord, it comes to 4 hours. So, in 4 hours, if there are two teachers from pre-primary to class 5, my lord, two teachers cannot teach all the 6 classes every day. One class has to be left out.
Yes.
No, no, no. So, my lord, the basic mechanism of surplus determination is faulty. There cannot be any surplus. The term should be a deficit in a school. No school is having a surplus teacher because, my lord, whatever a school teacher is appointed can be appointed in a school or posted in a school by two means, my lord. One through appointment or another through transfer. So, my lord, suppose in a school, if there are sanctioned strength of 10 teachers, so, my lord, all appointments within 10 sanction strength cannot be said to be surplus because the government has thought that a sanction strength is required and accordingly that particular sanction strength has been approved. So, my lord, any teacher, whether on transfer or whether on new appointment, is posted in a school cannot be said to be a surplus. What it can be said that a school has a deficit teacher, but no school has surplus teacher. Now, my lord, if a school has deficit teacher, now, my lord, section 26 I have placed before your lordship says, filling up of vacancies. This is a mandate of the Right to Education Act. Why, my lord? Because deficit cannot be fulfilled, my lord, by transfer. There has to be new appointment. My lord, if appointments are not being made and deficit are being filled up by transfer, it cannot be, my lord. This is barred by the Right to Education Act. Now, my lord, if a teacher is within the sanction strength, he or she cannot be termed as surplus. Because, my lord, when an appointment is made, my lord, today an appointment is being made. I chose a school because there is a sanction strength, advertisement has been made. Now, after my appointment, a notification comes that you are surplus, you are transferred. This cannot be done. My lord, these are my submissions on mechanism. Now, my lord, as far as this determination of surplus, if at all, let us presume the best case for the respondents. My lord, your lordship is with the respondents that there is surplus every after two teachers, third teacher is a surplus, and my lord, this SOP is tenable in the eye of law. In all such cases, now the question will come, my lord, determination of surplus. My lord, determination of surplus has to be, my lord, in terms of the last joining. Because, my lord, suppose two teachers are already appointed, a third teacher has been appointed in a school, thereafter the ratio exceeds. So, first two teachers cannot be made to suffer for the appointment made by the authorities by appointing the third teacher. So, has to be the, my lord, the last teacher joining the school. If at all, my lord, this your lordships upheld this and everything, I would say there is no surplus concept in a primary school. There can be a concept of deficit teachers.
Yes.
Because, my lord, why I am saying this? My lord, with an appointment in a public post, my lord, the incumbent or the employee carries some right with it. One of such right, my lord, is a seniority right. Once I get an appointment, seniority, transfers are all incidents of that service. I carried with me, my lord, till my retirement and till my service tenure, the concept of seniority. Now, my lord, if this biological age is considered, my seniority rights are being prejudiced.
Yes.
My lord, now all this, my lord, I am making this application on biological determination of surplus, taking into consideration, my lord, your lordship is with the respondents and SOP and everything is tenable in eye of law. Because according to me, as I have submitted, my lord, there is no surplus. Now, my lord, if this surplus SOP is taken into consideration, my lord, your lordship has already seen it is an undated, unsigned document. Can, my lord, a constitutional court rely on such an SOP and, my lord, uphold such an SOP when there is no one to take responsibility of such an SOP? Now, my lord, let us take the best case for the authorities. This SOP has been issued in executive capacity and it has been signed. My lord, your lordship knows an executive does not have a power unless it is given to an executive to issue any notification or any order. It does not have a power on its own. It has to be given, it has to derive the power from somewhere. It has to be some rules or some act or anything. Now, my lord, if your lordship kindly comes to the Primary Education Act 1973, Volume 1, my lord, Section 107.
7.
107. Primary Education Act.
Yes.
Your lordship, let me I read. Power of state government to issue notification or order in place of making rules. So, my lord, at best, taking the best case of the respondents, it can be under 107. Now, my lord, I am placing 107. Notwithstanding anything contained in section 106 or elsewhere in this act, the state government may issue any notification or order or for carrying out the purposes of this act for which that government does not consider it necessary to make rules, or issue any notification order not inconsistent with the provision of this act in place of making rules under this act, if shall government consider it is necessary. So, my lord, this SOP relates to transfer. There is already an existing rule of 2002 which the government has deemed fit to, my lord, frame under section 106. So, when there is already a rule under 106 and that 2002 rules does not provide any power to the executive to supplement the gap in the transfer rules, my lord, this SOP is not tenable in the eye of
But the SOP, if it is consistent with the provisions of law, then 107, the government can invoke 107 and come up with a notification in the form of SOP.
my lord, provided, subject to correction, my lord, what is the subject? 107 talks about, my lord, if in this, if it's in that subject, my lord, the government feels not to make any rules. My lord, what my understanding is, if the subject is the transfer here, my lord, the government has deemed fit to promulgate a rule, my lord. So once the government has promulgated a rule, even if, my lord, there is a gap in the rule, some gap, my lord, it has to be meted by way of an amendment, not way of an executive instruction, because, my lord, executive instruction cannot override the rules.
Yes.
This is the 2002 transfer rules along with the amendment. If your lordship kindly see 2002 original rule 3 and how it has been amended. 162. Rule 3 says role strength in terms of Right to Education Act. So if it is terms, then cannot be any surplus. There can be deficit at most. There cannot be any surplus concept. And my lord, if your lordship goes to the rules, I am not placing it. There no authority has been given to the, my lord, executive to fill in the gap. My lord, in the absence of a rule, administrative instructions or GOs can be, my lord, made. But when there is a rule, if there is any gap, the only way out is the amendment. So, my lord, if I sum up my arguments, my lord, first, in primary sections, my lord, there cannot be any concept of surplus. There can be a concept of deficit, and that deficit has to be determined, my lord, considering the minimum requirement in a school. Where there is 6 teachers, in every school, minimum requirement is 6 teachers, and my lord, that beyond that, it can be considered. Though, my lord, Right to Education Act says appointment is the only way out if the vacancy exceeds less than 10%. And my lord, as far as the mechanism, my lord, I say that the mechanism they have followed, that is 40:1, 30:1 is the permissible limit, above 200, 40:1, that is not the correct mechanism, my lord. It will create more chaos. No, my lord, at present, this has to be, my lord, what mechanism they have followed, my lord, has to come by way of an affidavit, because some person has to take responsibility. My lord, in the meantime, if I or my learned seniors, my lord, have managed to make out a prima facie case, now, my lord, the balance of convenience is in our favor, my lord, because if the transfers are affected, there will create a chaotic situation all over West Bengal, and the entire writ petitions will be infructuous. Even, my lord, interim order, if granted, they let them come up with an affidavit explaining their stand. Otherwise, my lord, this entire effort and writ petition will be infructuous. I would pray, my lord, this SOP shall not be given effect to till your lordships hear out the deeply.
তুমি কি আছে স্টেটের who is appearing for item number 2 for the state.
For this state. My lord, Mr. Loknath Chatterjee was appeared.
In item number 2.
Yes, madam. Loknath Chatterjee.
লোকনাথ সব জায়গায় আছে, অনেক অনেক জলে জঙ্গল ধরে পড়ে।
Item number 2 for the state respondents. We received this matter very fresh yesterday only. Kindly give us some time so that we can take instructions.
Where is he? He was there. Item number 2.
অন্যদিন আমাদের কোনো আপত্তি নেই।
Who is for the state in other matters? Item number 3.
Item 3, Mr. Chaturvedi is appearing, and item 4, Mr. Chatterjee. 5A, Mr. Chaturvedi. 5A or Chaturvedi?
Oh, Mr. Chatterjee has come. Yes.
Primarily, my lord, I have, my lord, sought for detailed instructions, but my lord, have not received them. But my lord, as far as, my lord, the issue of the Right to Education Act is concerned, my lord, the issues of in the scheme, my lord, which they are trying, my lord, to lay emphasis on, Right to Education Act, my lord, talks of, my lord, a minimum number. My lord, we will have to appreciate on what basis and under what circumstances, what was the objective, my lord, of coming up with the Right to Education Act. My lord, the Right to Education Act, my lord, was a constitutional mandate, Article 21A, my lord, that had to be done, my lord, free and compulsory education had to be provided. So, my lord, there the resources of the state are strained. In those circumstances, my lord, to give a minimum number, my lord, of teachers, my lord, that was the ratio which was laid down, my lord, which has been stated as per, my lord, number of pupil teacher ratio has been given. My lord, the pupil, my lord, under no circumstances does the pupil teacher ratio, my lord, militate against the SOP which has been, my lord, brought about, and also does not go against, my lord, the scheme, my lord, of the Primary Education Act, my lord, which they are laying stress on. My lord, they have, my lord, as per what I find, my lord, it's only the Primary Education Act, my lord, on which they have, it's a primary my lord, school. So, my lord, under the Right to Education Act, my lord, up to 60 students, minimum number of teachers is 2. My lord, 61 to 90 it is 3, and my lord, 91 to 120, my lord, it is, my lord, the schedule to the act, my lord, pursuant to sections 19 and 25, my lord. So, my lord, 91 to 120 is 4, 121 to 200 is 5, my lord, and above 150 students, 5 teachers and 1 head teacher. My lord, the scheme of the act of the Right to Education Act under the constitutional mandate is based on an entirely different thing, my lord, compared to, my lord, what is done here. My lord, here, if my lord will be pleased to take, my lord, the SOP, my lord, if I'm placing for my lord's kind convenience, my lord, the standard operating procedure. My lord, this I believe item 4, if I think he was arguing, my lord.
Babu. Item number 2 to only argue করতে
19857 টা শ্যামল কুমারটাই দিন তাহলে
No, you are in 2. You are arguing 2. If you refer to 2, then we'll take up 2 only.
My lord, since he completed with 4, I'm starting. I'm sorry, my lord.
Oh, you are with 4.
My lord, 2.
So which brief are you
with 4, my lord. 4. Shyamal Kumar. My lord, 2
Okay,
is
then
also there, but my lord,
in all of the writ petitions they have annexed.
it's similar, my lord. So standard operating procedure in 4 is page 17, the Shyamal Kumar matter.
Yes.
My lord has that. My lord, if I may please. Standard operating procedure for transfer of teachers and non-teaching staff from zero enrollment schools and rationalization of surplus teachers. My lord, so that is the, my lord, nomenclature, my lord, of the standard operating procedure. My lord, I'm coming to the objective. To ensure optimal utilization of available human resources by rationalizing the deployment of teaching and non-teaching staff through the transfer of personnel from zero enrollment schools and schools having surplus teaching and non-teaching staff to schools experiencing a shortage of teaching and non-teaching staff as indicated by a high pupil teacher ratio. My lord, in my most humble submission, this is in aid of the Right to Education Act. This is in consonance with the Right to Education Act, not in disagreement with that act, my lord.
Yes.
My lord, the objective of the Right to Education Act is to ensure, my lord, that universal education is offered, my lord, to all students. And here, my lord, we are faced with a situation and a scenario where, my lord, for whatever reasons, there are, my lord, zero enrollment schools, thousands of them in Bengal, my lord. So these zero enrollment schools are there, and, my lord, schools having surplus teaching, non-teaching staff. So, my lord, the objective, my lord, as we can find, my lord, from the standard operating procedure, is for rationalization of this. So, my lord, in zero enrollment schools, so what it means, my lord, is, so there are no students, teaching and non-teaching staff are there, my lord, they are having to be paid. My lord, for what purpose? We do not know, my lord, their primary objective is to impart education. And, my lord, there are areas and places, my lord, where there is a shortage, my lord, of teachers.
Yes.
My lord, shortage of teachers, my lord, in the rural areas. My lord, shortage of teachers, my lord, in the non-urban agglomerations. My lord, no, in the non-suburban areas, my lord, there is a, my lord, gross shortage of teachers, my lord, and non-teaching staff. My lord, only Right to Education Act, my lord, solely looking at it is not enough. My lord, we will also have to look into the midday meal scheme, my lord. My lord, there are students, my lord, through this scheme, my lord, also the midday meal, my lord, is offered to students, my lord, who come to schools. So, my lord, along with this educational objective, my lord, there are other laws, other regulations, other schemes in place, my lord, which have also to be addressed through the school system.
Yes.
My lord, through the school system, my lord. So, the objective, my lord, I believe, my lord, in my most humble submission, the petitioners cannot have any quarrel with this objective, my lord. My lord, now I'm coming to the next portion, but, my lord, as far as the objective is concerned, my lord, and if there are surplus, my lord, then if one is receiving, my lord, aid and assistance from the government also has its obligation, my lord, to ensure education reaches everyone till the age of 14 years, my lord. That's the mandate, my lord, of the Right to Education Act. This is in aid of that mandate. My lord, if in areas where the pupil-teacher ratio falls short, my lord, because that is the objective, the last line of the objective, my lord, says, experiencing a shortage of teaching and non-teaching staff as indicated by a high pupil-teacher ratio, my lord. So, therefore, the Right to Education Act mandate, my lord, in order to give it greater effect and to ensure that it reaches the last person, or rather the last student, my lord, that is the objective of this, my lord, SOP, my lord. So, there, just because I am a teacher, I am holding on to a position which is close to my house, my lord, I cannot claim to have any vested interest and vested right to stay there. There, my lord, I join issue with them. There, I say they do not have any vested right. They cannot claim to have any right to be in a place of their choice. Because, my lord, we are also guided by the Right to Education mandate. We will have to ensure, my lord, the schedule to the Right to Education Act of 2009, my lord, the pupil-teacher ratio which is there, it is ensured, my lord. My lord.
Yes.
Now, my lord, if I may place, my lord, the scope. This SOP shall apply to all government-aided sponsored schools under the administrative control of the School Education Department, except special school rule schools, and shall cover teaching staff in zero enrollment schools, my lord. This is important. My lord, teaching staff in zero enrollment schools, non-teaching staff working in zero enrollment schools, my lord. Surplus teachers identified in schools where staffing exceeds the prescribed norms of the RT Act 2009. Minimum required staff patterns in secondary schools. Secondary schools, my lord, is not an issue here. I'm not, my lord, joining issue on that. So, my lord, vis-a-vis the first 3 points of the scope, my lord, teaching staff working in zero enrollment schools. So, zero enrollment schools, which teacher, my lord, has a vested right, my lord, to say there are no students there, and then they will ensure, my lord, that very well, my lord. We are on the scope of the SOP. My lord, just in order to appreciate the scope of the SOP, my lord, so therefore the objective is zero enrollment schools. They cannot have any vested right or interest there, my lord. Non-teaching staff, my lord, in zero enrollment schools, there cannot be any vested right, my lord.
Madam, I'm sorry interrupting, madam. Madam, in the primary school, there is no non-teaching staff.
Very well, my lord. I thanks to the jack in the box who keeps popping up. My lord, surplus teachers identified in schools where staffing exceeds the prescribed norms of the RT Act 2009. Who's, my lord, where is it said? Where does it appear that it is, my lord, not in consonance with the Right to Education Act? Or, my lord, there is a quarrel with the Right to Education Act? It is in order to aid the aims and objectives of the Right to Education Act, ensure the conditions in the Right to Education Act, my lord, are maintained. So, my lord, we do not see, my lord, any quarrel. It is in furtherance of the Right to Education Act, my lord. If I may be permitted to, my lord, use that phrase, my lord. My lord, the procedure. My lord, identification of schools with zero enrollment having teaching and non-teaching staff. My lord, the procedure is in a very objective manner. It has been laid down, my lord. Which has been done. Identification of teaching and non-teaching staff in those zero enrollment schools done. My lord, I'm also, my lord, looking into the scheme as a whole, my lord, SOP. My lord, we cannot look at it in a piecemeal manner, my lord, the way the petitioners want it to be looked at. It has to be looked at from a holistic perspective, my lord, in my most humble submission. One cannot pick and choose, my lord, a few lines from the SOP, my lord. My lord, 3, my lord, identification of schools with surplus teachers. So 1 and 2 are done. 3, my lord, is an ongoing as per the SOP, the 10 July 2026. Identification of surplus teachers. So, my lord, looks at, my lord, the objective parameters and the objective procedure in which they are proceeding, my lord. They are proceeding, my lord. First, they are identifying schools with zero enrollment, having teaching, non-teaching staff. Next, my lord, they are looking into, my lord, identification of teaching and non-teaching staff in those zero enrollment schools. My lord, it's a waterfall mechanism which is coming down, my lord. In a very objective manner, they are proceeding. My lord, then identification of schools with surplus teachers. Identification of those surplus teachers, my lord. Then, my lord, identification of schools with high PTR, my lord, pupil teacher ratio, having deficit of teachers, which means, my lord. So this is important, my lord. My lord, clause small Roman 5, my lord. Identification of schools with high pupil teacher ratio, which means there is a deficit of teachers. My lord, the district authority.
How many right now are zero enrollment schools?
My lord, those instructions I've sought for them, my lord. Exactly, my lord. I've not yet received them, my lord. If I may be given a couple of days, my lord, I will definitely, my lord, revert to with those instructions, my lord. My lord, those statistics, my lord, I've sought for, my lord.
SOP does not disclose so.
SOP says done. My lord, SOP will not get into, my lord, the figures. My lord, in case, my lord, it is my lord's pleasure, my lord, I will.
Okay, continue.
My lord. My lord, the DI secondary and DPSC for primary shall publish a list of schools having teacher shortages, which is a high pupil teacher ratio, indicating school name, district, block, circle, number and category of teachers required, including subject in case of secondary HS schools. So, my lord, here we are not, my lord, met with secondary school teachers here. My lord, so therefore, district DI will, my lord, DPSC rather, will publish a list of schools having high pupil teacher ratio, which means there is a shortage of teachers. And, my lord, what is to be indicated is also stated. My lord, identification of staff for transfer. All teaching and non-teaching staff posted in zero enrollment schools shall be considered for transfer.
Yes.
My lord, logically, there cannot be something against it, my lord. Teachers who are already placed on deployment may be transferred to the place schools if required as per pupil teacher ratio. My lord, surplus teachers from other schools shall also be identified. For determination of the surplus teachers of a school, teacher younger in biological age shall be considered first. However, any willing senior teacher may opt for being considered as surplus teacher. This is in bold, my lord. And I believe, my lord, they also have something to say regarding this, my lord. For secondary school, subject-wise surplus teachers would be considered. So, my lord, if I may, my lord, this point 7, teaching, non-teaching staff in zero enrollment schools will be considered. teachers on deployment may be transferred if required as per pupil teacher ratio. Surplus teachers from other schools have to be identified. And my lord, for determination of surplus teachers of a school, teacher younger in biological age shall be considered first. Any willing senior teacher may opt for being considered as a surplus teacher. My lord, here to give an example, my lord, everyone, my lord, has experienced or has experienced in situations, my lord, where in government jobs, transferable positions, my lord, people are given, my lord, their positions closer to home, my lord, at a senior age. So when you are young, you're supposed to travel. When you are young, you're supposed to be amenable and open to transfer. So younger in age, my lord, that is the principle which is applied, my lord, in any employment of this kind, my lord. This is, my lord, a general idea, general knowledge, my lord. Anyone who signs up, my lord, or has dealt with government jobs, my lord, or quasi-government, my lord, positions.
Okay. Yes.
My lord, next, my lord, secondary schools, subject-wise surplus teachers would be considered. My lord, if my lord is pleased to take the next page. For primary schools with low pupil teacher ratio, the concerned HT would not be considered as surplus teacher for transfer, being head of the institution, as there is no specific subject-wise post of teachers in primary schools. For determination of the subject teachers of a school, teacher younger in biological age shall be considered first. Now, my lord, here again they have, my lord, one logic of biological age which I have placed, my lords, for before my lord, for my lord's kind consideration. My lord, there has to be a rational basis and objective which criterion which has to be developed. My lord, in my most humble submission, my lord, there should not be, my lord, any objection, my lord, to an objective criterion, my lord, which has been devised in the sense, my lord, younger in biological age should be considered. My lord, so this is an, in my most humble submission, this is an objective criterion, and against this objective criterion, my lord, there cannot be, my lord, this. So my lord will be pleased to consider that an objective criterion, they may like it, they may not like it. There may be, my lord, 10 other options which can be which one can come up with. My lord, senior, my lord, junior, one may be senior in biological age, but my lord may be junior, my lord, in as per, my lord, employment, years of employment. There can be. My lord, there can be 10 plausible explanations, but if the explanation or the logic, my lord, or the objective which is contained in the SOP, my lord, is also tenable, it is also plausible, my lord will be pleased to consider that, and not, my lord, consider 5 other plausible explanations which may be there, 5 other, my lord, plausible, my lord, grounds which can be there, or conditions which can be laid down. My lord, whether it is rational or irrational, my lord will be pleased to consider. They will have to demonstrate that this condition, my lord, of biological age is not something which is, my lord, rational. They will have to demonstrate it is an irrational classification. That, my lord, in my most humble submission, they have not come up with. They have not demonstrated before, my lord, that this classification is not in terms of, my lord, the Right to Education Act, not in terms, my lord, of the primary education law, and, my lord, is an irrational classification. That is the hurdle and burden, my lord, which they had to discharge before my lord's court. My lord, the modalities for transfer. Identified surplus teachers shall be given an opportunity to submit their preferences from amongst the published list of high pupil teacher ratio schools within the stipulated timeline. So, my lord, they are being given, my lord, an option. Depending upon the application submitted by the surplus primary teachers, DPSC will take necessary further measures for transfer of such teachers in schools with high pupil teacher ratio having deficit of teachers. My lord, so the overarching objective, my lord, in my most humble submission, my lord, is, my lord, the high PTR is something which is playing in the mind, my lord, of the department at all times, my lord, of the commission, my lord, of the authority rather. Wherever there is, my lord, a high PTR and a low PTR, that is, my lord, the overarching objective, my lord, which appears throughout this document, my lord, being the standard operating procedure. My lord, first is identification of surplus teachers. Then, my lord, depending upon the applications. So, my lord, they are being given an opportunity to submit their applications. DPSC is to take further measures. My lord, for secondary level schools, the teaching and non-teaching staff posted in zero enrollment schools, along with these identified surplus teachers in schools with low PTR, will submit their preferences from amongst the published list of high PTR schools within the stipulated timeline to the concerned DI secondary education, who will then compile the same and submit the proposal to the commission for further course of action. Here they are not from secondary education, but nonetheless, this forms part of the SOP. Many schools which were upgraded in the last 10-15 years do not have any sanctioned posts, but all such schools are in dire need of teachers for the particular categories. Transfer of teachers from zero enrollment or low enrollment schools may be considered with post to schools with high pupil teacher ratio or in need of particular subject teacher with post. Well, this is very important, my lord. This is somewhere, my lord, I will draw my lord's kind attention to. Many schools which were upgraded in the last 10-15 years do not have any sanctioned posts, but all such schools are in dire need of teachers. My lord, what is the object? My lord, the school education system exists for the teachers only, my lord, or for the students? This is a question, my lord, I asked to myself, my lord. My lord, so it is entirely, my lord, the contention of the petitioners is entirely, I am a teacher, consider me, my rights, this is in contravention. But what about the students, my lord? What happens to their education? What happens to the mandate of the state, which is to provide education to the students, my lord? Where does that go? My lord, so this overarching objective which, my lord, emanates from this entire document, my lord, is schools are in dire need of teachers for particular categories. Transfer of teachers from zero enrollment to low enrollment schools may be considered with the post to the schools with high PTR or in need of particular subject teacher with post. It is, my lord, in aid of education, my lord, and for the students, my lord. This entire system exists, my lord, if I may be permitted to say, my lord, for the benefit of the students, my lord, not for the teachers solely, my lord, if I may say. Transfer orders, my lord, E, shall be issued as far as practicable based on the options exercised and administrative requirements. Again, my lord, a lot of, my lord, emphasis, my lord, first, my lord, is being given, my lord, to the students. Then, my lord, teachers give options, come up with options. We will give, my lord. They have, my lord, it is not their case, my lord, that we have given these options and my options are not being considered. My lord, there are two bases on which, my lord, it has to be considered transfer orders. My lord, point E, my lord, at page 18, my lord, based on the options exercised and administrative requirements. Now, my lord, they can come and say that the question of, my lord, administrative requirements has not been, my lord, done in a fair manner. That can be, my lord, that they will have to demonstrate. It is not their case, my lord. So the first is to be given, my lord, importance is to be given on the options exercise, my lord. By whom? By the teachers, my lord. And administrative requirements. My lord, if a surplus teacher fails to submit preferences within the prescribed period, or if the preferred schools cannot accommodate the teacher due to limited vacancies, the competent authority shall assign the teacher to any identified high PTR school based on administrative exigencies and educational need. Now, my lord, again the
Clause E, which you have indicated, clause E,
my lord,
there is a procedure laid down in Rule 5 itself, which is to be followed upon an application being made by a school teacher.
my lord.
Again, a clause has been you have incorporated a clause which says that based on the options and administrative requirement.
My lord.
But 5 gives an entire aspect of the procedure to be adopted by the council for transferring. If an application is made, what are the criteria to be? So this is an additional.
My lord. This, my lord, whether, my lord, this,
that the administrative requirement and options which is already in the rule, you are again bringing a fresh clause to section Rule 5 of that.
Yes, my lord. So this says transfer orders shall be issued as far as based on the options exercised and administrative requirements. My lord, now as far as, my lord, the rules are concerned,
come to Rule 5.
My lord, there are these more data. My lord, I'll just speak. My lord. Yes, so, my lord, I understand, my lord, what has fallen from, my lord.
এই যে রুলটা তুমি দেখাচ্ছি দর্শক যেটা বলছে রুল 5 এটা বলছে
হ্যাঁ রুল 5 যাচ্ছে
4 এতে can also transfer. This is a step
my
towards
lord. So my lord, in this case, my lord, if I may, my lord, also submit before in my most humble submission, my lord, the power of the council, my lord, is not taken away. So the power of the council to effect transfers, that remains. 5 is there, rule 5. So if I may be permitted to say, my lord, that the power of the council to effect transfers gives the council, my lord, gives the authorities also to come up with, my lord, or to incorporate this within, my lord, the SOP. So this power of the council does not get denuded, my lord.
SOP nowhere records that. Nowhere records that the transfer rules of 2002, this is in addition to that. Then
Well-
we'll reflect to that, because if you come to rule 5,
My lord, 4A
it
also, my lord,
begins
has
with the clause that 4B has to be complied with. Now, if you take a junior teacher, suppose he has qualified in 2025, the approval has not yet come, but the SOP says that you transfer the junior teacher for rationalization.
my lord.
So, rule 4B will be a bar. But if you follow the SOP, there is no such bar. You can transfer any teacher who has joined in 2025
My lord.
without approval. You cannot, without approval, you cannot transfer as
We
per
cannot
rule.
transfer.
But this SOP says that yes, you can transfer because he is the junior most teacher of that school. Can that be made?
My lord, also, my lord, this has also to be this is one, my lord, issue which I will have to, my lord, satisfy, my lord. The other issue, my lord,
I
which,
have followed you because RTE says that the schools have to be a minimum of teachers.
yes,
Upon survey, the government has come to this conclusion that there are schools where there is zero enrollment, the teachers are not functioning or they cannot function because they are not students.
my lord,
So their service has to be put in some other schools where there is deficit.
my lord, my lord.
But I am on to this that you have to rationalize on the basis of the existing rules that is there. If you say that this SOP is an addition to that and is not in contrary to the existing rules, then it will show that if a teacher joins in 2025, he is not at all approved, then where does he go?
My lord, here the scheme of the SOP, my lord, demonstrate that this should not, my lord, take effect on a permanent basis, my lord. The scheme of the SOP, my lord, because this is the identification. So this, my lord, follows a one-time process. That, my lord, is which is, my lord, this identification also. This does not say, my lord, this identification will be done periodically every year or in some. So, my lord, this from the looks of it, my lord, appears to be, my lord, a one-time process, my lord, where this rationalization is to be done. My lord, this is not a permanent process, my lord, which will take effect, my lord, every time. One cannot take, my lord, refuge to rationalization, my lord. This is evident, my lord, from a perusal of the scheme. My lord, so E, my lord, whether rule 5 and E, my lord, this is something which I will, my lord, try and, my lord. So if, my lord, if surplus teacher fails to identify, then, my lord, the authority will do it, my lord. My lord, transfer orders G will be issued, my lord, by the competent authority. Zero enrollment schools are having, my lord, sanctioned posts. All such posts may be withdrawn at the state level with appropriate orders to utilize those posts for the schools where needed. So, my lord, this is also, there cannot be any, my lord, quarrel with this, my lord. In the instance of closure of schools for transferring the teacher and non-teaching staff from zero enrollment schools to any other schools, concerned SI schools will take over charge as custodian and immediately inform, my lord, the state of the physical assets. My lord, so this is, my lord, in
What is
my lord,
in the page 19 annexure P3? What is this they have annexed?
my lord, that is something, my lord, they have annexed, my lord. This is whether, my lord, I've this document, my lord, whether it's a complete document.
Mr. Dasgupta, what is 19?
In 19 takega?
19 complete list of activities. My lord, in district Purulia, this is the list of schools which have been termed as surplus schools. I have only annexed my page, my lord. This is the document. There is no notification or forwarding letter.
Okay.
This is the school, my lord,
How many teachers are surplus? This has been indicated.
This has been indicated.
Oh, okay. Yes, Mr.
My
Chatterjee.
lord. My lord, now, my lord, in secondary, my lord, this rationalization is not the first time this is happening, my lord. In 2023, my lord, there was, my lord, the guidelines were published, my lord, 216 SE of 10th February 2023 with respect to, my lord, rationalization in secondary schools, my lord. That was already effected and done, my lord, in 2023. My lord, as far as primary schools are concerned, my lord, that notification did not apply, my lord. So, my lord, essentially, my lord, this was done by the Commissioner of School Education on 10 July 2026 for rationalization of teachers primarily, my lord, in primary schools. My lord, essentially, my lord, the Commissioner of School Education has the prerogative, my lord, frame and communicate guidelines for the authorities to conduct the rationalization process, my lord. My lord, the objective being the overall pupil-teacher ratio, my lord. My lord, there is, my lord, no express policy, my lord, of the state, my lord, for pertaining to guidelines, my lord, for rationalization of teachers in primary schools. So this is why, my lord, the state had to come up, my lord, with these, my lord, guidelines, my lord, and the authority, my lord, is not something, my lord, which has to be.
But then you are following the subsequent one, or both are prevalent as on date?
My lord, a rationalization again,
But there are two SOPs.
My lord, one is of 10 July 2026.
So government is following the subsequent one or the earlier one, both are prevalent?
My lord, there was a 2023, my lord, that was for
No, no. There are two guides. They are shown in the morning. There are
166.
Item number 5 and 6 both the SOP.
5 and 6 টা আপনার
5 টা দাও তো।
That is the subsequent one which I have.
Yes, then both are prevalent as of now, or only the subsequent one?
But my lord, 10 July, I have been told, my lord, 10 July issued by the Commissioner of Schools is, my lord, so whether both are অন্যটা কোথায় আপনার কাছে আছে?
Last one will
ওটা আমি মানে না জেনে বলতে পারবো।
দাও না 5 টা দেবনাথ বাবু, আইটেম নাম্বার 5 টা দিন না,
অন্যটা ডেট
5 বা 6 টা দিন তো।
10ই জুলাইতে চিঠিতে বলছে দুটো এসে আসবে, টাকা পড়ে নাও, কিনে নেওয়া হচ্ছে। না না লেখা আছে, কখনো রিভাইজ হওয়ার পর না না সেটা
এটা দিয়ে দুটো পাওয়া যাচ্ছে।
এই কোথায় একটাই
repetition. Page 164 দেখো। 164 আর 166 সুবিধাটা দিস না
একই তো কি চেঞ্জেস 10 জুলাই দুটো
বায়োলজিক্যাল যে ফ্যাক্টরটা আছে না সেটা সেকেন্ড আর কোনো চেঞ্জ বাকি সব
কিসের চেঞ্জ আছে
বায়োলজিক্যাল এজ
7D, there is a change in 7D. Now 7D of the previous one, it has also recorded once noting that it is pertinent to note and mention that there are no provisions in existing rules. Now the subsequent one, that sentence has been deleted and the entire process
biological
to identify the surplus teacher has been changed. Now, which one is prevalent today?
ইনস্ট্রাকশন দিয়েছে আপনাকে কিছু এটাই নেই my lord, in the instructions which I have received, they advert, my lord, to younger teacher, younger in biological age shall be
So
selected.
the
as
subsequent ones. Subsequent ones.
Yes, that is what I, my lord. In the instructions which I have received, my lord, clause 7D, it has been stated that teacher younger in biological age shall be selected as first surplus teacher.
Okay.
হ্যাঁ, কপি নিয়ে নেবো নাকি? এত লাফালে হবে? My lord, 7F also, there is the biological age has been introduced once.
You are holding which brief? Read
My lord, I am holding the one which Mr. Biswas just handed over to me.
It is 19893.
My lord, 19903.
19903. যাও তো এটা যাও।
না না যশাবের কাছে কোনটা আছে?
I am with 19893 of 2026. This is
এটা এটা না,
Nistha Devnath.
Yes, Mr. Devnath is item number 5.
তাহলে এটা
এটা দেখো, এটা
My lord, it's the, my lord, I've seen, my lord. There,
No. What I am into is there is a letter of the chairman which has been annexed to that writ petition. The paragraph starts with all sub-inspector of schools are requested.
পেজ পয়েন্ট
Page 163 of that.
এটা না, যশাব এটা দেখাচ্ছে, এটা দেখ,
না কিছু করতে হবে না। ফটো আছে।
দেবো, খুলে দেবো,
দিয়েছি
বাবা, এত উদার কবে থেকে হলো?
কপিটা দাও।
বাবা, জীবনে দেখিনি এত উদার হতে।
দেখো, এই ফার্স্ট আর সেকেন্ড দুটো একসঙ্গে রেফার করা আছে। যশাব এটা জিজ্ঞেস করছে, এখানে দুটোই যখন রেফার করা আছে তাহলে কি দুটোই অ্যাপ্লাই করছে? এটা দাও, আমি বলে দিচ্ছি।
First and revised SOP.
So the persons who have filed their application at the time of the first prevalent of the first SOP, that rule will apply in case of those persons. After a cutoff, an application has been filed for them, the revised SOP will apply as per this letter. Is it so, Mr. Banerjee?
Lordship, I have no instruction.
But then how do you apply the SOP then?
I will.
Lordship, let him complete, we will follow him linear.
First SOP, within send the received transfer applications from zero enroll, temporary posted and willing surplus teacher as per first SOP within today, and send the remaining received transfer as per revised SOP.
So clause D of 7 is
D and F.
is not equally applicable to all the persons.
Yes, D and F, both introduce biological age.
So there you
There is something, my lord, as far as
differentiate between the date of application.
date of application.
Any other submissions? You
Lord, as far, my lord, I'll take instructions, my lord, on those points, my lord, I will address, my lord.
yes. Then Mr.
Yeah, my lord.
You are in item number
But I am in item number 5, the brief that my lord is holding.
19893.
My lord.
Oh. এটা আগে থেকে সান্নাল সাহেব একটা
My lord,
yes.
Lord, 574 persons, my lord, have joined together. They all belong to and serve under the North 24 Parganas District Primary School Council. Now,
Yes.
well, I do not see that in respect of service matters which are individual in incident, Lord, there is any jural relationship inter se between any of the petitioners or altogether all the petitioners cumulatively. In the absence of such jural relationship, whether, Lord, the parties joining together in this writ petition espousing a common cause can be entertained in invocation of prerogative writ jurisdiction or not.
Yes.
The issue is no more res integra, my lord, a coordinate bench. Lord, pass an order, my lord. Justice, Honorable Justice. Yes. Kindly permit me to read not the first paragraph. 310 individuals claiming to be unemployed youths, having registered their names in the concerned employment exchange, have joined together to file the instant writ petition, praying inter alia for a writ of or in the nature of mandamus to issue the respondents, their agents and servants, particularly the DPSC Malda, being responsible to rescind, cancel, withdraw the entire selection process for the post of primary school teachers under the jurisdiction of so and so. In this context, we will kindly seize paragraph 4. After considering the submissions made by the learned advocates for the parties and upon perusing the instant writ petition, it appears that the writ petitioners had submitted their documents and testimonials along with biodata forms before the DPSC on diverse dates. There exists no jural relationship inter se the writ petitioners. The only common thread of joining as co-petitioners appears to be the status of being unemployed youths whose names were sponsored by the concerned employment exchange for recruitment to the post of assistant teacher in primary schools under the DPSC Malda. In my opinion, having regard to the facts and circumstances as stated above, this is not enough for the writ petitioners to join together as co-petitioners and instituting the instant writ proceedings in the absence of any jural relationship between them. In the case of Mota Singh, the Supreme Court was considering the question of whether legally payable court fees could be evaded by truck owners who simply joined as co-petitioners by stating in their petition that they were plying trucks for export of goods and had a liability to pay the tax impugned. The Supreme Court, while rejecting the office to scrutinize afresh each of the cases referred to in the office report and ascertain whether requisite court fee had been paid in respect, also observed inter alia, it is too much to expect the different truck owners having no relation with each other, either as partners or any other legally subsisting jural relationship of association of persons, would be liable to pay only one set of court fees simply because they have joined as petitioners in one petition. Each has his own cause of action arising out of liability to pay tax individually, and the petitioners of each one would be separate, an independent petition, and each such person would be liable to pay legally. It would be a travesty of law if one were to hold that as each one uses highway, he has a common cause of action with the rest of the trucks. Then, at this stage, it may not be out of place to refer to a division bench judgment of this court. In the case of Parul Devnath, the court, while considering an appeal preferred by the writ petitioners who were working as home guards in Andaman Nicobar organization, on the facts of that case observed inter alia that there was no need to direct the 130 writ petitioners to pay court fees for each of them, since it had not been held by the learned single judge that all the writ petitioners were not entitled to join in one petition. The division bench judgment, in my view, is wholly inapplicable, since the learned single judge in that case had not held that 130 persons were not entitled to join in one petition, whereas in the facts and circumstances of the instance case, there is simply no existence of any juror relationship inter se the petitioners as observed. So I am, my lord, at the moment raising an issue of, my lord, absence of any juror relationship inter se the petitioners, which would permit them to join, my lord, as co-petitioners. I am not as much on a curable defect of, my lord, permitting the petitioners to put in the deficit court fee, and then the subject matter in challenge is, my lord, 10th July 2026, whereby and whereunder the Commissioner of School Education has permitted
Yes,
that each of the district primary school councils, my lord, to rationalize. Now, this rationalization, my lord, is not, in my humble understanding, my lord, equivalent to the apprehensions, my lord, which have been raised of being transferred to a distant place, being otherwise aggrieved. Transfer is only a consequence of this rationalization.
yes.
There would be two things. When I challenge the policy to rationalize, I have to see whether the government is competent and empowered to rationalize or not. Is the very concept of rationalizing, my lord, uh, uh, vitiated by any mischief, my lord, any malice in law? If not, if it is not for attaining any oblique objective, then merely because, my lord, as a consequence of this rationalization, some persons, my lord, will stand to be affected. My lord, the policy of the government, my lord, cannot be faltered. The power cannot be faltered. My lord, the SOP, my lord, has been shown to my lord by each of the councils and also by my learned friend, my lord, appearing on behalf of the state, Mr. Chatterjee. I would not, my lord, trouble your lordships with that once again. But the relevance, my lord, thereof would be only in respect of, and in my understanding, my lord, the holistic understanding would be there are schools, my lord, where, my lord, there is zero attendance. There are schools where there are surplus. In view of upgradation, there are schools where, my lord, the teachers, there is deficiency of teachers.
Yes.
The process of rationalization is only going to deploy, my lord, the teachers in a rational manner. Transfer is only an incident of this process of rationalization.
Oh.
It can be nobody's case. None of the teachers can say that I cannot be transferred. None of the teachers can say that even if the school where I am studying, teaching, it has surplus staff, I cannot be the subject of this rationalization process. But if that be so, then, my lord, the decision making process, the decision to rationalize, my lord, is beyond any cavil of doubt of being, my lord, issued under competent powers. But kindly, my lord, for a moment takes up page 163. 162. This is, my lord, 10th July 2026.
Yes.
But this is Milord, the genesis. This is where Milord, from where everything stems. But kindly sees, this is issued by the Commissioner of School Education, the Government of West Bengal School Education Directorate, Primary Education, from the Commissioner of School Education to the Chairman, District Primary School Councils. And the subject is rationalization of primary school teachers.
Yes.
And what is not called upon, hereby requests him her to take immediate measure for rationalize primary school teachers in accordance with RTI Act 2009 on urgent basis by transferring teachers from school where teachers are surplus as per PTR of the school to the schools where number of teachers are deficit as per PTR of that school. I say this directive is in compliance of a statute. This spells out to be so that this exercise is being undertaken in consonance with the intent and spirit of the Act of 2009. And the district primary school councils who are otherwise blood fit and competent under the rules to transfer, they have been asked to do it. Now, Lord kindly sees page 163.
Yes.
163, this is an instance of North 24 Parganas. But the district primary school, the chairman district primary school council in compliance with page 162, Milord, is inviting Milord, options from the willing senior and junior teachers of the schools within particular dates. And then Milord kindly sees Milord, the SOP Milord is enclosed. So my lord would see, my lord, who is undertaking the exercise of transferring, but the exercise is being undertaken by, my lord, the council. Now, my lord, kindly comes to the rules. Kindly comes to, my lord, page 168. These are the rules, my lord, relating to transfer. At the risk of repetition, my lord, I say that the process is for rationalization. Transfer is incidental, for which SOP is being issued. SOP, among other, also deals with transfer, and it is being now implemented by an authority who is otherwise competent. For that, I take my lord to page 168. Now, my lord kindly sees 4A. Lord, condition for transfer.
Yes.
The council may on its own motion. So it is not, my lord, that the council on its own motion cannot transfer. The transfer can only happen at the instance of the applicant or of an incumbent. Now, to implement this SOP, the council has invited for option at the same time. This is, my lord, on its own motion in terms of 4A. In terms of 4A, now, my lord kindly sees that if any of these 574 persons, my lord, who is transferred, he is transferred, he is aggrieved by it, whether the statute gives him a remedy or not. Kindly sees, my lord, page 170. Kindly sees rule 10. A teacher aggrieved by an order of transfer may Now kindly see below 10.2. Such an aggrieved teacher shall, before preferring an appeal against an order of transfer under these rules, be required to comply with the order of transfer. So this is where the shoe is pinching. Rationalization, I have not heard much, Milord, that 10th July 2026, Milord, has been challenged, saying that the government does not has the power to rationalize. Now, if government has the power to rationalize and to manage, Milord, the teachers under its control, then it has to deploy. Now, this deployment would be in the form of transfer from a place from where there is a surplus to a place where there is a deficit. And this is in consonance with the rules. And once this happens, Lord, he has a remedy under Lord 10, but he has to go. The challenge has today been thrown with regard to not as much, Milord, the process of rationalization, but to the effect of its implementation, that it will entail transfer, and each one will have to go and join, and each one will have to prefer an appeal thereafter. So why not club together, file a common cause, say that the entire process is bad. But this issue of mass transfer of teachers fell for consideration, more particularly Rule 4A, before a coordinate bench. One teacher came up and challenged the process of transfer of about more than 300 teachers. Well, the court held that the council has the power to transfer, and in such policy decisions, the court would not interfere. This is 2022 SCC Online, Calcutta 769. Prashad Kumar Shamanto. 2022 SCC Online, Cal 769. ও কি আকাশ থেকে ফেলে দেন, যেটা এয়ার ড্রপ না কি বলে দাও করে দেবে। Kindly see paragraph 1. The petitioner is a primary school teacher. He is aggrieved by the transfer order dated so and so, issued in favor of the chairman, in his favor by the chairman. The petitioner has been transferred from so and so school to so and so school. Now, my lord, kindly come to paragraph 14, my lord, straight away. It has been submitted that the order of transfer was passed by the school education department, not in respect of the petitioner alone, but in respect of 390 teachers for the interest of primary education to maintain the student-teacher ratio of primary school. The said decision was taken for rationalization of primary teachers to ensure proper distribution of teachers among different primary schools in the state by way of transferring primary teachers from schools running with surplus teachers to the schools having deficit teachers. It has been submitted that the services of the petitioner is transferable and he has been transferred within the same circle where he was serving, not relevant. It has been submitted that according to the provisions of law, there is no bar in transferring teachers on the basis of the number of years that he has put in. The school education department published a list of so-and-so teachers who were surplus in their schools, and accordingly they have been transferred en masse. It has been denied that there was any malafide intention while issuing the order of transfer in favor of the petitioner. It has been contended that it is for the employer to decide when and where to post an employee for extracting best services from him. The respondents rely on the judgment passed in so-and-so, wherein the Honorable Appeal Court was of the opinion that the teacher belongs to a noble profession and he has a very rigorous responsibility of laying the foundation by enabling character and morals in the young children. The teacher has more responsibility than any other person in the society, and he has to make sacrifice even at his own inconvenience for building up a strong nation. Then 18 also relies upon a judgment in Joginder Singh, wherein the court had held that it is entirely for the employer to decide when and where and at what point of time a public servant is transferred from his present posting. Ordinarily, the courts have no jurisdiction to interfere with the orders of transfer. Then, paragraph 21 refers to rule, 20. I have heard and considered the rival submissions made on behalf of the parties. The petitioner, being a primary teacher, is guided by the West Bengal Primary Education Transfer of Teacher Education so and so rules 2002. Rule 4 of the said rules lays down the condition for transfer. It mentions that a council may, on an application from a teacher, transfer an approved teacher within its jurisdiction from one primary school to another primary school on the condition that such approved teacher is confirmed and has completed minimum 2 years of continuous service. It further mentions that the council may, if it considers necessary for proper utilization of service of primary teachers in the interest of education, transfer an approved teacher without maintaining any time limit of service. Without maintaining any time limit of service. It was, my lord's query, as to whether any time limit is prescribed or any manner is prescribed as to who should be transferred first. The rules, are silent on that, but there is a bar with regard to transfer. I shall come to that. The said rule further mentions that where there is a surplus teacher according to roll strength, the council may, on its own motion, transfer such approved teacher without maintaining any time limit of service by way of rational adjustment of teachers in a primary school. So, what is, paragraph 23, my lord. As of now, there is no provision in the service rules of primary school teachers that the transfer can be made on the principles of last come, first go. On the contrary, the transfer rules prescribe that transfer of approved teacher may be made without maintaining any time limit of service for proper utilization of service in the interest of education. Relying on the aforesaid rule, the petitioner was transferred. The same is certainly. It is settled law that an employee whose service is transferable do not have any vested right to remain posted at a particular place. It is for the employer to decide when and where to post a particular employee for extracting best services from him or her. Transfer being an incident of service, courts ought not to interfere with the same in a casual manner unless there is reasonable inference or malafide action pleaded in the petition. The order of transfer ought not to be interfered with. This takes care of two things. One, that the action taken is in consonance with the rules. The rule, has vested, the council, with the powers to transfer. And the rationalization policy is leading to culminating in transfer, which again, if until unless shown to be, smacked with any malafide, would not be interfered merely because, a personal inconvenience is being caused, to any of the teachers. Insofar as the policy, insofar as, the policy decision of government is concerned, the courts, are always, slow to intervene and interfere in it, because it is, exclusively within the domain of, the executive, how it, manages its affairs. Today, all of us are before my lord because of the precarious condition that the system of primary education of the state is in, where there are teachers who are sitting and gossiping because they don't have students to teach. There are students who are sitting and playing and making pranks because there are not sufficient number of teachers. So this imbalance, is sought to be addressed by the government. This cannot be seen to be vitiated with any oblique motive. Cannot be seen to be without any rationality. This cannot be termed to be arbitrary. This cannot be termed to be unjustified. This cannot be termed to be irrational. Then, my lord, I put a question to myself, my lord, as to why, my lord, my lord's prerogative jurisdiction, my lord, would be invoked. My lord, kindly permit me to cite 2006 volume 10 Supreme Court cases, page 337. And my lord would kindly not come directly to paragraph 11, which would be, my lord, at page 7. But the pagination, my lord, would get at left hand side top, my lord, in very small letters.
Yes.
Paragraph 11, while exercising the power of judicial review of administrative action, the court is not the appellate authority and the constitution does not permit the court to direct or advise the executive in the matter of policy or to sermonize qua any matter which under the constitution lies within the sphere of legislature or the executive, provided these authorities do not transgress their constitutional limits or statutory powers. হয়নি পিটিশনটা গল্প হয়ে গেল Now, my lord, kindly, my lord, permit me to pause here for a moment. My lord, I say which of the SOP clauses of SOP, my lord, are found to be, my lord, in contradiction to what the objects that is sought to be achieved, qua either the RTE Act or qua the rules of 2002 which permit transfer. Blood, in my humble understanding, 10th July 2026 not only spells aloud that it is being done for complying the provisions of 2009 Act, and the enabling provision for transfer, my lord, lies in the 2002 rules, my lord, 4A, which I showed to my lord. Now, the scope of judicial inquiry is confined to the question whether the decision taken by the government is against any statutory provision or is violative of the fundamental rights of the citizens or is opposed to the provisions of constitution. Thus, the position is that even if the decision taken by the government does not appear to be agreeable to the court, it cannot interfere. Lord, with deepest of respect, if I may say, my lord may not agree, my lord, with the manner in which this rationalization is being done. My lord, as human beings, we all have, my lord, opinions. Lord, my lord may opine that there can be a better way of doing it. There may be an alternative means which will cause lesser inconvenience. But then, if my lord is imposing that, or my lord is asking, my lord, the executive to act in a particular manner, my lord, then paragraph 11, in the beginning it says, then the court is sermonizing. The question is not, my lord, one of agreeing to the manner in which the executive functions. It is to find out whether this is impermissible because it smacks of arbitrariness, it smacks of irrationality. This cannot be permitted to be done. The correctness of reasons which prompted the government in decision-making processes, taking one course of action instead of another is not a matter of concern in judicial review, and the court is not the appropriate forum for such investigation. My lord, my submissions find being buttressed, my lord, in paragraph 6. The policy, I'm sorry.
Yes.
The policy decision must be left to the government as it alone can adopt which policy should be adopted after considering all the points from different angles. In the matter of policy decisions or exercise of discretion by the government, so long as infringement of fundamental rights is not shown, the courts will have no occasion to interfere, and the court will not and should not will should not substitute its own judgment for the judgment of the executive in such matters. In assessing the propriety of a decision of the government, the court cannot interfere, even if a second view is possible from that of the government. Then, the court should constantly remind itself of what the Supreme Court of United States said in Metropolis Theater. The problems of the government are practical ones,
Yes.
and not like Mr. Sanyal's clients, individual ones. But these are my additions.
Yes.
The problems of the government are practical ones and may justify if they do not require rough accommodations, illogical, it may be, and unscientific. But even such criticism should not be hastily expressed. What is best is not always discernible. The wisdom of any choice may be disputed or condemned. Mere errors of government are not subject to our judicial review. Similar, the government, my lord, has decided, I would say, the object is pious. The object is pious to ensure that each and every corner of the state, it gets, there's a equal, we expect distribution of monsoon, Lord, which is, Lord, the gift of nature. Lord, today an endeavor is being made, Lord, to spread the distribution of education to each corners, Lord, of the state, and for that this endeavor, Lord, has come. I beseech your lordships, Lord, merely because, Lord, some persons, they, Lord, apprehend that the transfers may not be in consonance with their choices, or that some inconvenience, individual in nature, will be caused to them. But their apprehensions may be wholly misplaced, because they may, my lord, stand to gain by these transfers, because it's all, my lord, in the womb of the future to see. But merely because, my lord, this apprehension is there, but it is too early, my lord, to say, to judge that the entire process is smacked with such an arbitrariness or irrationality that it calls for an interference in, my lord, high prerogative jurisdiction of this honorable court. Those, my lord, huh?
Yeah.
Consider. That's done. So, my lord, my first, my lord, limb of argument, the writ petition should be the writ petition, my lord, should be dismissed, my lord, in view of the decision that I have shown to my lord. Lord, even if, Lord, my lord, entertains the writ petition on merits, Lord, I say that these are, my lord, policy decisions, Lord, which do not smack of, my lord, any arbitrariness. My lord would not, Lord, pass any interim order, and, my lord, kindly direct, my lord, filing of affidavits. We have just been served with copies of the writ petitions yesterday in the evening. My lord, we had no time to seek instructions. Most of us, Lord, on the right side of the petitioners, they faltered in answering to my lord's queries, because, my lord, when by the time we got the petitions, my lord, we had no officers available in the office of the directorate to answer our queries. And in the morning, my lord, we came to, my lord, meet the arguments of, my lord, stalwarts, my lord, like Mr. Sanyal. So we had no time, my lord, to cope up with the array of woes that came to us. Writ petitions, my lord, should.
Thank you.
But my lord, just to add, my lord, if I may, my lord, small query which had fallen from my lord regarding Rule 5, my lord. My lord, just to address that point, my lord, Rule 5 is based entirely, my lord, on under, my lord, clause B of Rule 4, and which is, my lord, where the concerned teacher, my lord, makes an application himself or herself. And, my lord, here this is Rule 5 will not apply, my lord, in my most humble submission, because it relates only to Rule 4B. Here, my lord, we are under a case, my lord, of Rule 4A. There, my lord.
Huh.
So that is where, my lord.
I mean, for a
And
No,
my
no,
lord,
no. Because in your SOP you have given that they can give option. Giving of an option means he is applying for the
yes,
particular.
that option does
So
not.
it's not that on own volition the council is acting. The
Right.
option is also given to the teachers that you come up with an option which school you want. That's why I said that the transfer, as far as practicable, it says that arising out of option being given or for administrative reasons. Both are there.
my lord,
So on own volition as well as on an application made by the teachers giving an option that these three schools I am opting for.
my lord,
That is there. So 5B, 5 will come.
my lord, the exercise is under 4A. How I implement 4A, Lord, again, is not a discretion which will not I Lord, preserve with me. Until unless, my lord, it is found to falter with, my lord, any of the rules. I say that you go to this school, I am transferring you. Instead of doing that, since, my lord, large number of teachers are, my lord, in the process of being considered, and since it's the process of rationalization to cause least of inconvenience, we say, very well, I am intending to do this. You can, however, give your choices. Now, the moment I ask for choices, this does not automatically get relegated to 4B. I am still exercising in 4A. Because 4B would be, without my asking, he comes and tells me that I want to go.
Yes, my lord. Yes, my lord. Just to add, my lord. So therefore, my lord,
একটু,
4.
একটু, একটু,
एक-
একটু,
হ্যাঁ,
একটু, একটু,
বলে দিন, কিছু বলবেন না?
একটু। So 4A, my lord, is the power. The rationalization, my lord, is to be done. The commissionerate asks the councils to do it. Council exercises powers under 4A. But it, my lord, also seeks the convenience. This is, my lord, how the trajectory, my lord, of the entire process goes. But have I been able to answer my lord's query? To the best of my ability, my lord.
In 4 has a two aspects. One
Yes.
is of out of own volition and another is by way of an application. Now you're telling that exercising the volition by way of an option being also called for
As
founding.
I, my lord, submitted to my lord. My lord, kindly sees, my lord, 4B.
Application.
But on an application from a teacher, transfer approved teacher. But here is a case where, my lord, the teacher is saying that I want to get transferred. He exercises an option. He applies. We will consider whether we can transfer him there or not transfer him. Give him a hearing at best. Now 4A. 4A, I can individually transfer, my lord, him to another place. This is not a case of one individual. We are looking into, my lord, our assets. We say the teachers are our assets. We are trying to manage our assets and we intend to put them to least inconvenience. So we say that surplus teachers, you give your options. We try to accommodate to the extent possible whatever option you exercise. But this asking for option does not, my lord, relegate my action to 4B. It still remains to be under 4A.
Yes.
Right?
Excellent. It is.
I'm grateful to my lord.
4B.
Lordship, my
আমি কিন্তু ওইভাবে হাই তুলিনি যেভাবে তুমি তুলছো।
as far as item 6 is concerned, my lord, my all points which I could give a reply is already covered by council and my senior councils as well. Lordship, one aspect only one I want to give it to your lordship for.
এটা দাও item number 6 টা দিন।
Lordship,
Item number 6 টা দিন।
Lordship, we have to see today the issue is whether before I get a chance to controvert with my facts and figures, is this document under question is so irrational that it has to be immediately stopped giving any effect. We are all three are arguing today on a premise whether this is so irrational that has got an immediate bad effect on the entire system as a whole. It's not like that only one gentleman will be transferred by this or two will be transferred by this. So if your lordship really thinks that this required consideration, then lordship, we will also take instruction and we will come back to your lordship. So today, lordship, my seniors and the councils for the state has already given a direction that this is a arguable matter. It can be this side, this can be that side. But Lordship, so far as the brief which I am holding, is there any one environment which shows that if it is not state today, then the consequences are this, or a irreversible state will appear? Because I have to only judge the situation. If it is not state, then what is the effect within coming 7 days? So, Lordship, I have to see from the environment. The environment speaks about, now Lordship kindly takes up 6 and the grounds therefore. If we now look into the grounds, very quickly we will go through the grounds once, Lordship. Lordship will find none of the grounds are said which is per se affecting or leading a situation of mayhem condition. These grounds indicate that your this provision may not tally with this. Lordship, if we just read it quickly, it starts from page 31.
Yes.
Lordship, kindly see, this ground talks about in elementary education there is no teacher concept. So that then next 2n defines school. Then 3, 8d of the Act, duty cast of the appropriate government to provide infrastructure including school. I think this is, in fact, is for that the said norms and standard for the school such and such in respect of such and such. So this is also a fact. Then 5, one teacher unless we have to wait. Then Lordship, kindly see the 6. The given situation where the respect of the school in paragraph 8, number of the student are below 6, but there are the student in each and every classes from primary to 2, but it is admitted number of teachers are taken 2, then there is no teacher to teach the student for the rest of the 4 classes. So Lordship, what now? Lordship, kindly turn to paragraph 8 of the.
Yes.
Now Lordship, paragraph 8, they have tried to demonstrate for the purpose of convenience, appreciation and perception of the contention and submission of the petitioner best. Lordship has got.
Yes.
Based on the fact with regard to this, the Lordship, they have said that this is the total strength, this is the assistant teacher, head teacher. Number of surplus assistant teacher is 2. Now they are saying, I have got a surplus assistant teacher. If you take that back, so situation is this. So Lordship, what they are trying to show is after implementation, something will happen this. There is no emergent situation. Now Lordship, kindly turn to the next. Roman 7, page 34. Then 8, first sentence. For that per clause such under the heading procedure of the SOP, head teacher is not considered as a surplus. This clause is entirely against the provision of this as such, and we read the provision such and such. So Lordship, then if we take the 9, which considerable in number of primary teacher in this, at least separate one classroom for every teacher does not physically exist, for example. See, so this is Roman 9. Lordship, that is talked about that. Then must be one special educator for such and such. So these are the things they are requirement, nothing to do with this SOP. Now Lordship, kindly 11. For that to elaborate and advance the contention of illegality, arbitrary, malified, unconstitutionally of the SOP, the revised SOP will take the reference of such and such, such and such. For that, the revised SOP such and such under the heading such and such surplus teacher in the school are to be identified, determined such and such, the prescribed norm in case of the school such and such. The 2 assistant teacher out of the 3 and 1 such and identified as surplus for the reason that are admitted 39 students. That is to say that less than 60 students. Therefore, the said school is entitled to have only 2 assistant teacher. fallacy is that the state cannot have a head teacher and their way. So, Lordship, what they are saying is, if it is at all implemented, what is SOP intended? Now, Lordship, kindly turn to the SOP. Now, Lordship, kindly see. Either you, Lordship, can come to 49A and 49C. To ensure optimal utilization of available human resource, which is submitted by my learned senior, that national development of teaching, non-teaching staff, the transfer of the personnel from zero school such and such, surplus such and such, a shortage of this non-teaching staff indicated by high pupil-teacher ratio. The scope shall apply to all government such and such and shall cover teaching working in a zero, non-teaching this, surplus teacher this, minimum required of stature this. Procedure, then identification.
Yes.
So, Lordship, what I am trying to show is, it is a procedure, administrative procedure has been opted to identify. Is it, I put this question to myself, is it not too early to understand that this is the administrative procedure, this will be executed, and then that will result to this anomaly? So, anomaly which my learned senior opponent friends tried to demonstrate is a system or a future which might come out of this. And come out of this is in what sense? It might lead to a situation according to them. If I even for a moment, if I feel that what they said is correct, then in the process may lead them to a situation. So, can I halt that process today? I put this question to myself. But my learned senior, my counsel for the state has stated that give us 7 days time, we are coming back to it. So, Lordship, they have to show that even 7 days is so grave that cannot be altered by the court. That case has not been made. I observed the hearing, I found that the final hearing on this issue is going on. We state has not received any chance to controvert them with my statistics and data. What is my thought process of publishing this? I have my objectives. I have my collective intellectual decision on the issue. I have not been able to place before you. So today when we are in an ad interim stage, they have to show that even 1 day sustenance of this SOP is so irreversible in nature. Lordship, I have tried to show from the document that this is not there. My second point is, if we take a further holistic view, the transfer policy, Haryana. Lordship, this optimizing policy, I will not restrict myself to see only this West Bengal. Whether these is there in other state or not. Lordship, this other states is having a same option. Assam, Haryana, Odisha, Andhra. This operating system, Lordship, today we are handicapped because yesterday that has been served upon me. So, Lordship, I can show, if your Lordship give me a not transfer policy, that optimal rationalization. So, Lordship, if we take the state of Haryana, I have a transfer policy there. I have a optimism policy there. If your Lordship, laptop mobile, if your Lordship allow us even a evening's time tomorrow morning, I can place this before your Lordship. So, Lordship, then optimization of the resources is there in other states. The hue and cry which has been made today, that this has been done by the state of West Bengal and this is So what I today say before your lordship is, then this entirety of says 3 category are being dropped out. Now let's go back to their issue. Head teacher, then option, which has been clarified by my learned senior, option, head teacher, and their preference. So if this particular document is taken, and lordship, if your lordship, which has been much argued by them, that is, if teacher in biological age, lordship, teacher with the biological age, lordship, that has been narrated by my seniors, but lordship, kindly see the restrictions. If your lordship see the rule, even after age of 57 and something, there is a bar on transfer. Just saying 57, 58, there is a bar on transfer. So which is submitted by my learned counsel for the state, that younger in age, more easier to adopt in a new place. Now, lordship, when it was argued by Mr. Majumdar, he constantly said that this is in violation of a constitution, in violation of a national policy. I have shown, at least in my draft, my brief, there is no contradiction they have shown that this is against national policy. There is no one ever meant in the grounds they said that this is against the national policy. They have to indicate that this is the national policy which is in contradiction to this, and the effect is this. So far as pleading is concerned, because I am not in a position to controvert that pleading, pleading has to be enough clear before your lordship today.
For education has not been adopted by the state of West Bengal as of yet.
He argued, but that also has not been. So, lordship, what he argued is also not reflected in the grounds. Now, lordship, kindly see the document which he has annexed at page 50. The West Bengal primary education, page 50, lordship, they have annexed it that if this is existing, then how that SOP can come. That was another limb of their argument. Now, lordship, kindly take 5. Where this is applicable. 5.1. A teacher seeking transfer under the clause B of 4. Lordship has got. So, lordship, moment they talk about this is a teacher seeking transfer, and mine is for the optimization of the resources for a object. So here what they have annexed and say this is contrary to, lordship, do these two things hold a 2 different field. If your lordship just permit me, I can hand over this policy to your lordship. Haryana. আমার নেই গো, এয়ার লিফট এয়ার ড্রপ দুটোই নেই, আমার কাছে একটা অন্য ট্যাব আছে, হোয়াটসঅ্যাপ করতে এই দাদা দেখুন, এটা ট্রান্সফার পলিসি, এটা একটা ন্যাশনাল পলিসিও আছে। তো দাদাকে এয়ার ড্রপ করো।
Which clause you are referring? Mr. Banerjee?
Yes, ma'am.
Which clause?
Lordship, I am just saying this clause are quite akin to this policy which is under challenge. I found my learned senior opponent are also ready with those two. So, lordship, what I'm saying today is the concept introduced here is not a.
Yes.
The concept introduced here is not a alien to the knowledge of optimization. So what I'm saying is, we can come back to your lordship with our documents and there is no emergent situation by which Lordship can protect them, or there should be a interim order in someone's favor.
Related to what is
And
the
then
last-
Lordship, if your Lordship kindly come to the prayer.
No, there was a last date fixed for submission of any option of that, anything of that sort.
6th August.
3rd August.
6th August. 31st July and 6th August.
6th August. Is there any date fixed for submission of any option or?
I tell you losses. The option comes later. First, identification of the surplus school and surplus teachers. That has been done in my by the council. So my right has already been affected because I have been declared either surplus or deficit. So on the basis of options, SOP says if I do not give options, they will take action. And they will look at this.
No, I'm coming, sir. Page 48.
48.
Yes.
Yes.
May I take my lord shortly?
The sub-inspector of the school are directed to check, verify and forward the received transfer application of the teachers to the undersigned by this.
Yes.
With their clear forwarding notes and official recommendation. Lordship has got.
Yes.
So Lordship, what I'm saying is, as of today and for the coming 7 days, no case has been made out, because though they said it's a set aside, but basically from the argument it seems that they are challenging almost the constitutional validity or the virus of this SOP. Now the second question will be before your Lordship, which we will be arguing is it an administrative direction or it is a constitutionally valid document which we are trying to look at? Whether it is in aid of a policy or implementation of a policy, or itself it is under any statute or rules or under constitution. If today we are talking about a constitutional validity, illegality, rationality, then the presumption has to be this SOP is pursuant to a statute. Judgment paper. Lordship, judgment. Lordship, there is a plethora of judgment which says, if it is an administrative thing for a purpose, so there is no hurry either for the court, because administrative action, it can always be set back to his original position by the court of equity. So once the SOP is there, and which is, it's not a constitutional conformity document, not in conformity of the constitution, which may say that it might lead to a clash with the constitutional provision, might lead to. And I will try to show it cannot. It is just to implement it for a situation or to attain an object. As my learned counsel for the state submit, it might be for one time, it might be for the second time. It's an operation, because unless I do this, but I try to implement something, then the individual discretion of the officers come into play. What is the object of this SOP? The object of the SOP is not to have an independent individual prudence to implement. A collective measure to be taken in this methodology. So what we are talking about is SOP, this discriminates. That goes, if we goes to the more root of it, if we go to the more research of it, Lordship, we will. Yes, that's right. So Lordship, this SOP is a minimum standard procedure to be followed so that the discretion of individuality not come into the way. The very object of this SOP is,
what the question which is going through my mind is,
yes,
what I also put to him, that you are placing SOP of two structures. One, you say that the subsequent one, you say that the junior most is to be transferred.
true,
Correct? That clause was not there in the earlier one.
true,
The principle which was there, that was different from what was made in subsequent. But the both are prevalent. Now, suppose for the sake of argument, if it is placed like this, that tomorrow you take out an SOP and say that the persons who have attained 30 years, they will be transferred. For rationalization, the SOP says rationalization, but you fix a age, 30 years. What is the rationale behind that? Why the other clause, which was there in the earlier one, has been given, that tomorrow you take out an SOP and say that the persons who have attained 30 years, they will be transferred. For rationalization, the SOP says rationalization, but you fix a age, 30 years. What is the rationale behind that? Why the other clause, which was there in the earlier one, has been given go by in the subsequent one?
true, very true.
And it also records, which I find from, if you have the copy, it says that there are no existing rules relating to such provision.
Lordship, that
Subsequently, that particular line has not been recorded in the coming SOP. We all know that there is no existing such policy how to make out a surplus teacher who will be transferred out of 4. If it is, for example, there are 4, who is to be transferred? So that is not there. But that particular noting of the earlier one is not in the subsequent one. And there is a change of the principle. So we might expect that the third SOP which will come will be having some other principles.
True.
I concede that for rationalization it is required, because there is 0, so he is not discharging any function. So he has to go. But what about these principles which has been indicated in 7D? There is a change, and both as per the letter of the
7F.
chairman, both are prevalent. Both are prevalent. You apply for some set of the teachers, the earlier one, the subsequent you apply in case of other teachers.
True.
So what is the rationalization behind that?
Lordship,
As far as the
Yes, Mr. Banerjee.
Lordship, now let's place it in a way they can pitch their case that high that there is no rationale in it. Now, Lordship, kindly see, what is this SOP about? SOP is not about procedure to transfer. The very basic, my learned senior friends have pursued the SOP as if it is the procedure of transfer. I say the procedure of transfer will come later. This is the procedure of identification.
But under
Now, I'm coming. Allow me 3 minutes time. So, moment we think it is the procedure of identification, even if suppose Mr. X applied the first and he said such and such person will be, because he is not youngest, but he will be given, and another person says he will be youngest, so another council says Mr. X, and another council says Mr. Y is not the youngest, and here which comes from this council, they say he is the youngest, because this is the alumni that is falling from your lordship. This is the situation. Now, lordship, kindly see page 48 and 49.
tomorrow. We'll continue tomorrow.
Yes.
But then I take your answer tomorrow on the question which I have.
Yes, lordship. I will be
Again,
trying my.
it is the prerogative, remains the prerogative of the council to make a SOP and apply that.
Lordship, SOP.
Equally, it should be applied to all. Why then subsequent 2 SOPs? Come back tomorrow.
Yes, lordship. Yes, lordship.
Will give reply.
My lord, item number 1, kindly take it.
I have been requested by many of my junior colleagues to record an order for today.
Yes, yes. Same orders, Sabha Court, heard.
Very fast hour.
Huh?
Because you can
The whole day it is going.
control.
First order, ending have to fix it. Item numbers করে করে দেবে না? Item number 2 তে heard Mr. Vikas Ranjan Bhattacharya, learned senior advocate, appearing for the petitioners. Mr. Item number 2 who appeared for the state, Mr. Chatterjee. Item number 2 who appeared for the state.
I am told and I'm appearing in 2 to 4.
I'm told.
2 to 4.
Yes.
2 to 4.
Mr. Loknath Chatterjee, learned advocate, appearing for the state respondents, also places his points of argument. Place this matter tomorrow for further consideration. Last item number 6 e korbe Mr. Shiv Shankar Banerjee.
Lord, in item number 2, I am for the district primary school.
You give your name, that will be recorded.
Yes.
You continue with that. Kalke rekho, tomorrow.
PM Lordship, kindly keep it at 2 PM.
2 PM, my lord, I believe my learned friends for the appearing for the state will take 2 hours.
They will come to take that one.
Then, my lord,
No.
spill over to Thursday.
But we are facing
Finally,
financial
it's a pressing circumstance.
Shubhodaya.
8 July notification clearly says that act on urgent basis transfer. That's the exact order.
First order রেখে দাও 11টার সময়।
My lord, item number 1, kindly take it Friday. Moilay Bhattacharya cannot attend the court in this week, my lord.
Item number 1, well, I'm prepared to assist you. also.
My
Next Monday it will be taken.
All right.
Next Monday তে রেখে
Not except Monday. Except Monday.
My lord, Mr. Sharma is not aware, my lord, he will not be there.
দেন অন ওটা একটা অন্য ডেটে হিয়ারিং এ ডেট না হিয়ারিং এর লিস্টে মঙ্গলবার দিয়ে অন টুইসডে
Yes.
এক নম্বরটা টুইসডে তে দেবে ফার্স্ট আওয়ারে ফার্স্ট আওয়ার শেষ করুক অনেকটা হয়ে হ্যাঁ বিশুর ভট্টাচার্যের আগে বলে দিচ্ছি
May I seek your lordship's indulgence? Should I?
ইয়েস
But there is a madrasa matter which is urgent. Is in the list on every Wednesday it is appearing. There is some urgency.
on Friday you